Hello, everyone. It's Pam Esquire, also known as the Law Intellect. We're here to discuss all things legal. As you know, we discuss things all the way from the neighborhood to Hollywood. We analyze, we critique, we commentate, and we give our unsolicited opinions. What we don't do is give any legal advice. So if you do need any help from an attorney, please contact a local attorney near you. Now, you, my friends and family, are my law intellects. That means as I go through all of this legal stuff, I need you to analyze with me. You're my co-counsels. So I want you to comment below, and I want you to like, subscribe, share, and let everyone know that the law intellect is on.
Hello, everyone. It's Pam Esquire, also known as your law intellect. I hope you guys are doing well today. Speak to me as you come in. Hey, Travera Q, good evening. Gwendolyn, good evening. Good to see you. Hello, Novi Whitfield. Hey, sister. Ray Bishop, as always, good to see you, sir. Gloria Edwards, good to see you. Shelly Pender. Hey, Lynn. Oh, thank you so much. Just got back from federal court. You know, that's blue, black, and brown. Colors are very minimal. Hey, Lonnie, welcome back. Hey, Leela, welcome back. Yes, for those of you that joined me this morning, we discussed Daryl or Darrell, however he pronounced it, Brooks, and his sentencing, and we were able to together witness what the impact statements, what they're like at the sentencing phase. I didn't finish watching it. Did you guys finish watching it? It was a bit too much for me. When the kids started talking about how it affected them and those that lost sibling, I was done. Those that had survivor's remorse, there were kids that had survivor's remorse. Thank you so much. No, they don't technically limit it, but they technically limit it. Like when you're in school, they kind of tell you this is what it is. Federal court is very strict on what they want to see. Yeah, it became very overwhelming. I was just like, okay, well, I got to do something else. I wanted to see if Daryl Brooks, what his family would have to say. I was just curious. Because I think it was the grandmother or maybe it was the mother apologized to the family and said it was like some type of mental illness that he suffered from. Yep, kids talked. I think the last young lady, she said she was a senior. She was a clarinet player and she was in the parade. And I mean, she sounded so depressed. She sounded so sad. And she said that it's oftentimes that she relives this over and over again and she wonders why it couldn't have been her. So she has that what they call survivor's remorse. The other people around you passed away, but you lived and you still have an opportunity to do something with yourself. And she says she'll never be the same. I mean, it was a lot. Yes, it was so sad. I peeked in and that child read everything she went through. I had to click Lonnie. Listen. You and me both. Very sad. Thank you. Thank you so much. I appreciate it. Hopefully you'll love today's content. If you guys read the caption, I am going to talk about the lawsuit that Nicki Minaj's husband, Kenneth Petty, filed against the state of New York. What is interesting to me is I know over the weekend, a lot of articles picked it up and I've seen some bloggers talking about it, but he actually filed this lawsuit earlier this year and it's just a hearing was not set until January. So I think that may be why people are talking about it. So what I wanted to do is give you some background so that you guys can have a perspective before we look at the complaint. And I almost guarantee that you'll probably look at this in a whole different way from a legal lens than what's out there kind of as a sensationalism because of who it is. Now, because of the sensitivity of the content, because we know a lot of us know, and I'm going to tell you in a minute what he was convicted of, he being Kenneth Petty, Nicki Minaj's husband. I'm going to use alternative words because this is YouTube. So there's certain words I'm just not going to use, but you guys going to have to pick up what I'm putting down. Thank you guys. You guys said I look studious. Thank you so much. Yes. So I want to give you guys some background for those of you that don't know. Kenneth Petty is the husband of Nicki Minaj, who is a rap superstar. And he did some prison time back in, I believe it was around 94, 95-ish. And he was accused of a form of attempted assault. So we're not going to say the word of what it was, but we all know what it is. According to the young lady, she said that she was at a bus stop and he came up behind her with some objects and then forced her to go into a house and some contact occurred that she didn't want. According to him, and I think Nicki Minaj said this as well, she's saying that there was a relationship. But nevertheless, he pled guilty and he got like 18 months to 54 months, and he did just shy of 4 years. After he did that time, apparently he was accused of I don't even want to say of somebody died. And he was accused of that and he pled. So he pled to attempted of that assaultive behavior. And then later on, he got out after he did his time. And then he went back on some other charges and did a nice length of years. I believe it was like 7 years. If anybody is a fan and really keep up with this, you guys can let me know. Because I just got the background just so I can be able to analyze this complaint with you guys and at least know where all of this originated from. So, in order to properly analyze this complaint, I'm looking at the comments too. Some of you guys still talking about Daryl Brooks. I think you need to have some background. So, what happened is, as I told you, he pled to an attempted SA. And while he was there, the laws changed in the state of New York. Many of us have seen where people have to register when you're accused of certain things. People think it's only SA, but it's really not. It can be kidnapping. It can be what is the other one I'm trying to think of? Unlawful imprisonment. It's more than just that. And then there's also levels to it when you're accused of this. So what occurred was around the 90s, many states started doing registries. So many of you have heard of that, where you can look in your neighborhood and you can see like who in your neighborhood is on this registry. So this happened for a lot of people that were already doing their time. So this happened with Kenneth Petty. So he was already in there doing his time when the law changed where you had to register if you were accused of certain crimes, and one of them was the one that he had committed, allegedly, or that he pled to committing. Okay. He claims, of course, now that it was a consensual. He may have claimed that back then, but we can't revise, that he did plea. So what happened during that time is New York automatically just put people on that. You had to sign up and be on this registry because of what you were convicted of and was doing time. So, of course, it started a whole lot of lawsuits. A whole lot of lawsuits ensued because of it. One of those lawsuits was a violation of ex post facto laws. If you guys are familiar, remember back in the day, maybe when you were in your government class, you cannot be re-punished for something that you were already punished for. It's a violation of the ex post facto law. So basically, you cannot make it retroactive on people according to the Constitution if it's deemed punishment. Another issue people had with this was that you due process. You guys are adding more to my punishment. However, I have not been able to go before a judge and fight this like I would have, on any normal circumstance. Another argument has been double jeopardy. How you gonna add stuff to me again, and I've already been convicted, charged, been in prison for this. So there was a lot of litigation in New York and other states. Actually, there's still litigation on it as we speak. So there's a lot of litigation. New York basically said it's not ex post facto because they're saying it's not meant to criminalize you. They're saying it's meant to regulate. When it's regulatory, it's not criminal. So they're saying our purpose is to help for society and to the safety of the public. When you they said that we don't feel like it's any double jeopardy because we don't feel like we're repunishing you, we're just putting you on a list. And this registry now, it's a whole lot to it as well. So you have to put your name on notify depending on what level you are, but we'll get to that. So what occurred was one lawsuit actually went through and it was deemed that they needed due process. So that means all of those people, they were allowed to go back to court. The state had to tell them why they made them the level that they were, causing them to have to be registered and how long they had to be registered. They had to give them an attorney and they had a right to a hearing. And this was around 2004. This is what occurred. This is what caused all this stuff that's going on with Kenneth Petty, which is Nicki Minaj's husband. Originally, when he went in, he did not. There wasn't even a register. There wasn't nothing to register on because there wasn't even a registry. So now, once you get out, they have all these different criteria, and all this litigation was going on. So he was supposed to be allowed due process in order to see what levels, because there's different levels. There's different levels because you have one, because you guys know you have some people that they have the Romeo and Juliet where you're 16 and they're 18. Some stuff is consensual, but it's still a crime. You have older people and younger, there's levels to it. So apparently when Kenneth Petty first was convicted, his level was a level 2. So now, since now you have to register, you should have due process under the Constitution to be able to go in and say, hey, maybe I should be a level 1 because of all these criteria. And it's convoluted on how they even come up with these levels. They have a board and they have this unscientific method that's been challenged over and over and over again as to how they even do these different levels. So that's kind of how we got where we got today. So with that in mind, hopefully you guys caught all that. Let me see if there's any question. Okay, if you guys got any question, let me know, because this is how it happened. To be very, very simple, when Kenneth Petty went into prison, there was no registry. A year or two later, it became a registry. They just put it on everybody. Everybody got to register. And what happened is if you were tier 1 and 2, you had to be on the registry for 10 years. If you were tier 3, you had to be on there for life. That's how it was when it first happened. As time progressed, what New York kept doing was adding more to the registry. So now when you're tier 1 and 2, when you're tier 1, it's 20 years on the registry. And if you're tier 2 and 3, it's a lifetime registry. So it's even switched up a few times since he got on the registry. So now you have 2 and 3 is lifetime, but if you're a tier 2, after 30 years, you can request to go before some people and see if that you can be reduced or whatever, be off. So yeah, it's a lot. You said, was this just strictly New York State or were there other states? Almost every state has registries if you look up, but in Michigan here, ours was deemed, the way they're trying to apply it to retroactively to people that the registry didn't even exist. Our attorney general in our state, our courts have argued successfully that it is an ex post facto law and that it is punishment because it prevents you from doing a whole lot of stuff. First of all, it's like the Scarlet Letter, you know, and some of these really were like Romeo and Juliet type relationships, or, you know, you are being treated and thrown in the same bag as everybody else. And it may not have been belonged on that level. So I know here in Michigan, it's been recent. It was a big case that is almost probably going to end up trickling to other states as well, where they are saying that it's an ex post facto issue and that you cannot punish people all over again. They say it's not regulatory and that it is for punishment purposes. Pam, is that why one of the ladies retracted on what she said about him? I'm not sure who that is. You have to tell me what they said. So let's go over this complaint. Hopefully, you asked, is he gonna win against New York? We're gonna read this. I'm not sure he sued the right people personally, because under the 11th Amendment, they do have sovereign immunity. It's difficult to sue states. But let's not jump the gun, because that's why I said we're gonna have to kind of go through this. So here's the actual complaint that everyone has been talking about. And so let me go down to the statement of the claim. So what his attorney alleges, he's done what's called a 1983 case. So that's like a civil rights type of case, or a right against, and he's basing it on federal jurisdiction, which means there's a constitutional issue. So this is in federal court. So he says, on or about April 4th of 1994, the plaintiff herein was convicted by the Supreme Court of the state of New York, County of Queens, by plea of the crime of attempted in the first degree. Thereafter, upon information and belief, on or about August 12, 2004, pursuant to the New York State Offender Registration Act, which is also known as SORA, notice was sent by regular mail from the New York State Office of Court Administration to the plaintiff at, and it has the address. Said notice provided that the plaintiff could challenge his risk level under the Offender Registration Act, and that he was entitled to a hearing before a judge to have a new risk level determination. Because obviously, you guys, the lesser the risk, the lesser that amount of time you would even have to be on this registration. So being allowed the right to do mitigating circumstances, if he claims it was consent, that's his claim. If he claims it was consent, then he should be the right to say, well, this was a consensual situation and that's a mitigating circumstance, so that he can be lower, a lower level. Because now the laws have evolved so much that if you're a level 2 or a 3, that's life. Like everywhere you go, you're going to have to register. So it had the notice set a date for an initial appearance on October 26th of 2004 at 9:30 at the Supreme Court, Queens County, New York. The notice further advised plaintiff that he was registered as a level 2 offender with the defendant, New York State Division of Criminal Justice Services, and as a level 2 registrant. Now, mind you, this is October 26th of 2004. As a level 2 registrant, he was required to verify his address once a year for 10 years. So in 2004, the registration was 10 years for a level 2. Put a bookmark in that. Okay. The notice requested the plaintiff to respond to the Queens Supreme Court Correspondence Unit RM 714. It gives the address. It also asked the plaintiff to respond to 3 questions. A, do you want to challenge your risk level? B, can you afford a lawyer? And if you want a lawyer appointed to represent you, and C, if plaintiff was intending to appear on the date scheduled for his initial appearance in the risk level determination proceeding. The request received by the Queens Supreme Court was dated by hand August 16th of '04 and allegedly signed by Kenneth Petty. So he's saying he never signed anything acknowledging this hearing. The answer to question A was yes. The answer to question B was that Mr. Petty wanted an attorney to be appointed. And the answer to question C was that Mr. Petty was not intending to attend the hearing. Plaintiff was incarcerated from June 2003 until 2013 in the New York State Correctional Prison System and various facilities, and neither received nor replied to the notice or attached request. The plaintiff was never released from his incarceration during the period of '03 and '13 and did not reside at the address during that period. So plaintiff, which is Petty, alleges that the signature appearing on the bottom of the request is a forgery and doesn't even note his proper name, Kenneth Petty. So it has Kenny Petty, which is probably a nickname, as opposed to Kenneth Petty, which is his government name. Plaintiff alleges that he never had notice of the initial appearance of any subsequent hearings in the risk level determination proceeding. The Office of Court Administration should have sent the notice to the correctional facility where plaintiff was incarcerated instead of sending it to that address. The Office of Court Administration's failure to properly notify the plaintiff of his right to challenge his risk level under SORA and his right to appear at the initial appearance and any appearances thereafter violated plaintiff's right to due process in the violation of the 5th and the 14th Amendment of the United States Constitution. The New York State Office of Court Administrators and defendants had access to the proper address of the plaintiff and failed to notify plaintiff of his right. As a result of the violation of plaintiff due process rights being violated, the plaintiff was denied his right to have a hearing before a judge to have a new risk level determination. So the relief requested, the denial of plaintiff's right by the defendants have caused plaintiff to suffer humiliation, financial loss, arrest in California. Because if you guys recall, this is how this came back into the news, because apparently he moved from New York with his wife to California, and under the registry, you're supposed to register wherever you're located, and he failed to register. And I guess he was saying he didn't know he was supposed to register. And he got pulled over in Beverly Hills, and then they looked him up and they seen that he was on a registry in New York and had not registered even though he moved to California. Back in July, he pled guilty to it, to failing to register, and I believe he got probation. So he's saying that it caused the arrest, legal fees, being prohibited from carrying on a normal lifestyle by illegally being placed on the New York's offender registry, and this court should declare plaintiff's placement thereon retroactively null and void from the date that he was placed on the offender registry. So wherefore, it is respectfully requested that this court nullify plaintiff's placement on the New York ex offender registry retroactively to the original date that defendant's name was placed thereon, together with any other relief this court deems just improper. So, make sure I ain't lost you guys. So this is the complaint that Kenneth Petty has, let me put myself on here. This is the complaint that he has filed against New York, and those were his allegations. So now what I told you should make sense. If you guys are just joining and you missed, I explained how the registry started and how lawsuits ensued about the legality of the registry because many believe that it was like additional punishment. And at minimum, you should at least have due process. The courts in New York have agreed that you do need due process so that you can rate your risk because this is a lot. So when he got this allegedly, it was 10 years that you had to be on the registry. Now, since that time, let me show you guys what this registry since that time, now if you get on the registry, times have changed. And so now if you're a risk one, you got to do 20 years on the registry. If you're level two, you got to do life, but you can petition for relief after 30 years. And if you're risk three, you got to do life, period. So now you can see why somebody would want to go back and say, hey, can I present my case before the court to lower my level? Because if you were a level two back then, maybe you got some type of mitigating circumstances. So that was the issue that he had. Now, when you actually look at the state of New York's response, first of all, states have sovereign immunity. So as someone said, like, why didn't you sue the correctional facility? That's why you'll see people sue. Like when I've sued on things that I don't like the state has done, I sue the governor. So the governor is an individual. You can sue them in their capacity. People sue the warden of a correctional facility. They do those types of things. So typically you don't sue the state. So I don't know how that would pan over because you really do sue individuals. So that was a good catch. I don't know if the correctional facility he's not in there right now, so they're not wrongfully holding him. That's why when you get people that are in prison and they say they were wrongfully convicted and they go through the appellate process, the last process is to do a habeas, which is in federal court. They sue the warden because they say the warden is wrongfully keeping them there. So I don't know and he's out, so I don't believe that would be the proper person, but definitely the governor. Hey, Pam, how come Black people, no matter how rich they get, they cannot stay away from the whole life and creating or getting themselves in criminal activity? I thought money changed people for. Well, you know what? If you're referring to this situation, this was when he was younger. Like he was allegedly 16. I think they said he was 16 years old when he got in trouble. And I think the young lady was either 15 or 16 as well. So I doubt this was before any money was involved. Yeah. So now we're going to see the response. Basically the state's response is they asked to dismiss this case. And they're saying, and the thing is, what Kenneth Petty is saying does apply to a lot of people. I don't know if it applies to him, but under New York case law, they are allotted due process. They are allotted to go before and to say, hey, I want to challenge the level because look at the consequence. In my opinion, I think every time they change the statute, they should allow them to go in because over the years, New York has added more and more and more. So as you've seen at first, when he first got on the registry, it was 10 years. Now you're almost done with your 10 years because you have to look at it like this. He was in jail from 95 or whatever it was. He did 4 years. He gets out. He gets into some more trouble. He goes in for 7 years. His 10 years were probably about up. But then in 2006, they changed it again. So now you got to do it for life. So my opinion is I don't understand why they don't get due process if they tack more time. They just feel like they get due process to determine their level, but not as it pertains. They can keep adding stuff. And it's been a lot of litigation on this same subject in a lot of states, including New York. But New York is a stickler for this. They pretty much said We can add whatever we want to. We can add more time. We can add more restrictions. We can, because it's certain things like you can't get Section 8 housing. You got to be 1,000 feet away from schools. There's so many restrictions on it. Some people aren't able to get jobs, obviously. It's a lot to it that I think due process is something that should be guaranteed for something like this. But let's go to what the state is saying. Well, it's actually level 2 because they go before a board and they take all of the facts and circumstance because it was attempted. He pled to attempted. So it's a board that gives a recommendation and they have these like 10, 15 criterias, and they got this unscientific way of determining what level you are. So that's even being challenged right now because they're like, you guys are coming up with scientific ways to tell if somebody is going to reoffend or not, and there's really no scientific basis for what you're saying. Like, what? So this is what the state had to say. But I know it's a different perspective because people just look at it like, oh, it's Nicki Minaj and her, oh, she tried to sue the state, and they just kind of laughing at it. But there really are issues out there based on this type of this registry. There's a lot of issues related to it. So the let me go to the response. Let me see. So what the state of New York and the State Division of Criminal Justice Services did, those are the people that he sued. They filed a motion to dismiss. And their rationale, they're saying he basically did get his hearing and he's that's not true. So they say, so the defense, and this is Letitia James, the attorney general, that is responding to this. So they say, let's go down here. Plaintiff brings this action pursuant to 42 USC section 1983, alleging that his due process rights under the 5th and 14th Amendment were violated by the defendants for failing to provide him with notice of his '04 offender registration hearing, in which his risk level assessment would be redetermined. Although the transcript of the 2004 SOAR judicial proceeding demonstrates the claim is utterly meritless. Contrary to his allegation, plaintiff was present at the hearing and represented by counsel who stated that plaintiff did not object to his designation as level 2. The court need not even reach this issue. Plaintiff has sued only the state and a state agency, and the 11th Amendment obviously bars the claims. It's true, there's an 11th Amendment issue. The challenge to a 2004 hearing is also facially barred by the statute of limitation, collateral estoppel, and the Rooker-Feldman doctrine. So let's see what's important here. Plaintiff alleges that on August 12, 2004, a notice was mailed to, and it has the address, stating that he was registered as a level 2 and entitled to a hearing to have a new risk level determined on October 26th of '04 in the Queens County Supreme Court. Additionally, plaintiff alleges the notice reminded plaintiff the obligation to annually verify the address. Plaintiff further alleges being incarcerated only between June 2003 until 2013 in various facilities in New York. And during this time, he never received or replied to notice regarding his registration as an offender for either the initial or subsequent hearings. Further, plaintiff alleges that the Office of Court Administrators failed to notify him of the initial and subsequent hearing, and that this same agency and the defendant had access to his proper address. Finally, plaintiff alleges that his due process rights were violated. So this is just the standard of review on how the court is going to review this. Hold on one second. Hold on, y'all. I got to get my food real quick. Okay. So they first say the plaintiff's claims are barred by the 11th Amendment. So somebody brought that up, like, why did you sue the state of New York? To subject the state, its agencies, and officers to federal jurisdiction, the state's consent to be sued. So yeah, the states have to consent, like, yeah, we're going to let you sue us. So how often do y'all think that ever happens? And then it has the case law. And it says the 11th Amendment precludes suits in federal court against the state or its agencies absent the state's unequivocal consent to such suits. That is why you see people that sue individuals. Like the governor, like I've seen a lot of cases in New York against Cuomo for these type of cases. Yeah. So plaintiffs claim that he did not receive due process because he did not have notice of his 04 SOAR hearing is frivolous. So they're saying the case is frivolous. They saying plaintiff appeared and was represented by counsel. And this is the exhibit they attached. They have a transcript, and it has the people of the state of New York versus Kenneth Petty, and it's December 14, 2004. And on here we have all the appearances for the record. If this is the transcript they attached. He's saying he wasn't there. And it says, as you see, good afternoon, Judge. Miss Bishop was allegedly his attorney. It said, I think we have conference with Miss Michelson, and I don't think there's going to be a challenge to level 2 finding here, which is what the original board report in the court file reflects. The court says yes. Ms. Michelson says this matter had been on February 9th of 98. The defendant had appeared before the court at the time he declined counsel, but of course, based upon the federal disposition of these matters, meaning at that time, the court ordered that you're going to have all these people that you just made register that were already convicted and confined. You need to give these people due process so that they can at least fight their levels, because now you're going to be under the guise of the state supervision pretty much even longer, having to register. So the defendant had appeared before the court at the time he declined counsel, but of course, based upon the federal disposition of these matters, we are required to revisit the matter. Defendant having the right to counsel and the right to appeal. But as I look at the risk assessments instrument that was the basis for the prior ruling, the score came out to the upper limit of level 2. Even if there were any reductions anywhere along the line, it would still seem to be a level 2 no matter what, based upon the nature of the crime to which he pled guilty and the history of the defendant. So we're not going to contest it. So his attorney basically said they wasn't going to contest it according to this document. This is allegedly a transcript of which he was supposed to be there. So we're not going to contest it. I have spoken to the defendant and I've explained to him what's happening here, and he is satisfied with level 2. Now, also, mind you, at this time, if this transcript is true and accurate transcript, he would have been on the registry for 10 years. It has definitely changed. 2 years later, now you're on for life, which is the difference. The court says, based upon the score, we're limited by the standing they have set, and based upon that, I was satisfied back in February of 98 that it was a proper assessment. That being the case, our hearing is concluded, and Mr. Petty shall be assessed a risk level 2. Is there any instrument that are finding or any papers that have to be prepared based upon that? So the state of New York has responded and said you did get your due process. That's pretty much what their argument is. Their main arguments. So I was like, well, what is his attorney going to say after that? I'm like, they come with a transcript and say that you were there? What you going to say? So his attorney had something to say. He basically said, the defendants have claimed that he did attend the hearing. As proof, the defendants have produced as part of their motion an alleged transcript in which they claim the plaintiff had attended. There is a factual dispute regarding his attendance, which as a matter of law should preclude this motion from being decided at the present time, as discovery has not even begun yet in this matter. The plaintiff's attorney office is in the process of requesting the incarceration records of the plaintiff from the Bureau of Prisons to physically prove that he could not have attended the SORA hearing, as they did not permit him to leave the premises on the date in question. That as the records are pending, there would be no prejudice to allow the plaintiff to continue the case and receive the records to establish that they did not appear for the hearing, contrary to the claims of the defendants. That there would be no prejudice if the motion were denied, with leave to renew if the plaintiff cannot establish his claim of non-appearance at the hearing in question. Denial of plaintiff's claim at the present time would be premature prior to discovery being conducted. The plaintiff should have an opportunity to collect evidence to establish his cause of action. So then he gives a little bit of information of what occurred. So in April of 94, at the age of 16, the plaintiff pled guilty to section 110, 130.35, attempted in the first degree. Based on the conviction, he was classified as an offender subject to SORA. The primary issue at the current time was his claim that he was not informed as to the change of his status that required him to register. The plaintiff has claimed that he was not notified as to the change. Moreover, defendants had a legal obligation to inform him. Additionally, he could not have been notified by the state, as apparently the mailing address that the defendants had was his previous address that he was not residing in, as he was incarcerated at the time. Defendants have introduced a document that they purport to be a transcript of the plaintiff actually attending the hearing. Plaintiff has denied that he had attended the hearing in question and is in the process of obtaining records from the Bureau of Prisoners. Y'all. So what's going to be interesting here is, because there was an address that obviously they sent it to, but then they have a transcript saying that he was at the hearing. Why would you send it to the house if you knew he was in jail? It seems like you would have sent it to the prison. So he's still claiming he never got notice. He never knew anything about this hearing. And under the law, he is required to have notice and due process. Now, again, whether these were the proper people to sue, we have yet to see. So I know, like I said, I read a lot of stuff and I read a lot of magazines, and they kind of, people talk about it and they talk, but this whole registry thing is a very big issue, a contested issue in every state. It's probably about 6, 7 to 8 states now. I know we're one of them that has said that it is punishment because of all the different criteria and stuff. It's more than just regulatory. It's meant for punishment, and that you shouldn't be able to put people that this thing did not exist before on. So it's a big debate. Let me check some of your questions. Hey, Linda. Yes, challenging the transcript. Wasn't me. He said it wasn't me. Yes, if you guys are coming in, please hit that like. Please subscribe. You said they focused. Please don't say his name on here. They flag my stuff. Oh, thank you. Got a lot of new people. Thank you so much for coming in. Yeah, we try to get a little deeper over here as opposed to just surface. So but if you guys, I wanted you guys to see it from a different lens. That imagine this. So I actually had a ex post facto case. So imagine this, like you're a person, you get convicted of something. It don't have to be this. But people go into your legislative branch that don't like you. They like, I don't like Pam. She went up against me back in the day. She beat me at trial. I can't stand her. I end up getting in trouble for something where, say, it's nothing, but I get 2 months of probation. But because you're empowered to change, to add more punishment and just say, well, I'm not going to say it's punishment. I'm just trying to regulate people like Pam who got in trouble as an attorney. And I'm just going to change it where now she has to register or do A, B, C, D, and E. Now she can't do this. She can't vote. She can't be on she can't be on a jury. And they just add all these different things. Because the issue with that is this. You should know most people plea in order to have some certainty related to the uncertainty, if that makes sense. A lot of people plea because they'll rather know what their fate is as opposed to leaving it up to a jury and not knowing what the heck is going to happen. So if I go in and I say I'm going to plea and the prosecutor is going to give me probation, I think when I get done with my probation, then I'm done. But when you allow certain laws to take place, and that's not saying whether laws are good or bad, that's not even what I'm trying to argue. I'm just trying to let you know what due process is and why this is a due process issue if, in fact, he was not there. I personally think it was a due process issue that they raised more years later on. I think you should have a hearing every time they raised it, but apparently they already decided that ain't it in New York. So I think before, okay, he may not even fought the 10 years because it probably would have been up anyway. But what's making him fight today, what I believe, is because now it's a lifetime. You got a wife, you have a family, you have a kid. Yeah, I probably would fight it too. And there have been class actions related to this. He may not have pled if he even knew that he would have to get on a registry. You have to imagine that if he's saying that it was consensual and she's saying that it's not, and then they have video of her recanting, and then they have all this other information, why wouldn't he just roll the dice and just see, as opposed to, I gotta be on a registry? That wasn't even an option back then. That's the bad part. They didn't even have a registry. And that's called an ex post facto type of a statute. But they're saying, but all they do is they disguise it as regulatory. That's how they get away with it. Like they'll say, "Oh, we didn't do this. We didn't mean to punish you. We did this to regulate you." You said New York does have a habit of doing bogus stuff like that. Transcribes with the change the date. You said he's just using up his wife's money on his legal fees. And that's what she could have done. Well, apparently that was like her high school sweetheart or something. Guess you love who you love. Hey, Kwame, how are you? Yeah, it's a lot to this. So we're gonna see. He does not have a hearing until January, I believe it's the 23rd. I think they're going against the state. I think the 11th Amendment probably does apply unless you find some type of alternative. I believe his attorney said that you can go against the state. There are exceptions, so maybe there is an exception that he's found. But I would have sued the governor. And Letitia might have been on the plea as suing her as opposed to instead of being like the person that's going to represent the state. But there are due process issues when it comes to this registration stuff. And it's a lot of law in New York. New York is a stickler, though. New York is saying it's not punishment. They don't care how many lawsuits y'all bring. They don't care. They're like, no, we believe we have the right to do it. It's for the safety of our community, and that's that. And again, you guys also have to remember it's not just for those type of SA crimes. It's really are other categories. Some are misdemeanors. Some are, like I said, it was one class action in New York where they had to get on the registry, and it was because they robbed somebody in the house and it was in front of kids. And you had to get on the registry. And it was Megan, I guess it was a law there as to why they did that. Thank you. Yeah, so yep, y'all hit the like. I hope you guys enjoyed the breakdown of what's going on with the Nicki Minaj case. Because again, I saw a lot of commentators talking about it, just generally, just like, oh, he sued the state of New York. And actually, it's a very hot contested issue what he's suing them for. What they would probably have to do is get like the ACLU or something. So yeah. Thank you. Do you guys got any questions? I tried. So I know it gets a little boring, but I just want you guys to know what it was about. So Kathy said, "Is if Petty did attend this oral hearing, if this is determined to be factual, it blows up Petty's claims to due process rights were violated." That is correct. Based on the claim that he has presented to the court. Now, I would bring an additional issue on the whole lifetime registry, because even if he went to that hearing, as you seen, it was a 10-year registry at that time. Now it's lifetime. So to me, it sounds like in New York, they're a little petty, but to add, I would have an issue with you than added lifetime. Lifetime, 10 years and lifetime. So in his mind, though, he could have said, like the thing that happened in California, he could have thought he was off the registry. Because if you originally get 10 years and then you're already in prison when they change it again, like let's just assume, just for conversation, that he did attend. He attended this hearing, right? So if he attended this hearing, that was in 04. So what if he never got word in 06 that now it went to lifetime? So by the time he gets out, because he did like 7 or 8 years or something. So by the time he gets out, maybe he thought that he ain't have to do much more. So when he left in 2018 and went to California, maybe he thought he didn't have to do it anymore. If Petty current situation did not include a superstar money, he would be registering like he did before. He was registered. I think he had registered before in New York, because, well, we know he registered in New York because California was able to look it up and see that he was registered in New York. And then they also saw that he wasn't registered there in California. So thank you so much, Linda. I appreciate the compliment. Linda says, I'm very informative. My niece graduated from law school last year. Great to your niece. I wonder where she's taking the bar. I love to see new people in our profession. We need more people of integrity. We need more women, because it's oversaturated with men. And they try to be mean to us sometimes. Like it's 1920 and we're supposed to not be in this field. So, congratulations to your niece. You said his release date was September 10th of 2013 based on the DLC website. Look at Jessica. That's my researchist. My YouTube research. So 2013. So let's just say, so he was on the registry. Let's even just take it up to 2004 when he did his hearing and said, okay, I'll be a level 2. That's 10 years. So that means in theory, you would have got out in 2014? Off of the registry. And it probably was before that, because I'm assuming they backdated that. So what y'all think though? Like what y'all thank you. Thank you. You said he needs to pray, show enough. Yes. So what y'all think? But do you guys get it, like why someone would have an issue with that? And it's not even, I'm not trying to say who factually who's right, who's wrong, or whatever. I'm just trying to say like what the law is. Before you have any type of punishment, there should be due process under the Constitution. Interestingly, New York apparently doesn't have the same ex post facto clauses in their constitution. Most state constitutions mirror the United States Constitution, but apparently New York doesn't have the ex post facto. I had a whole case earlier this year with ex post facto, but it was a different issue. If anybody's from Detroit, you guys probably know the issues we had here with Mayor Kwame Kilpatrick, who got like an astronomical amount of years, which was totally ridiculous for some stuff he did in office. Trump did pardon him. Well, not pardon him, he's commuted his sentence. So he's still, convicted on paper and had to pay the fees. But what the legislative did during that time is to make sure Kwame came back and was like, I'll rise again like the phoenix and I will be back. And the state of Michigan legislature was like, nah, son, you won't be back here. So him and it was a couple of other people, they all got in trouble around the same time. They went up into our legislature and they changed it where if you got convicted of certain crimes while you were in office, you can never you can't run for 20 years. And they literally, we all know, like I read some of the documents from the legislature, they did it to prevent him. It was another councilwoman and it was her aide. They literally changed our constitution to make sure that these specific people, of course it affects everybody eventually, but that was the reason to change it. And I just thought that was like, it just was scary, So you can just not like me or what I did or whatever. Like I've done my time. I went away to the camp where I was on probation or whatever, and you got the ability to just go up here and change the law. I was just livid. I mean, the government told me to kick rocks, but still, I was still gonna fight it. I was like, this is not constitutional. This is ex post facto violation. She did her time. She wants to run for office. She should be able to. It's up to the constituents to decide if they want a convicted felon to be in office. That should be up to them. That should not be up to this to the legislature in Michigan. I was just really going hard. And they was just like, yeah, all right. They were like, I see what you're saying. It is kind of like a punishment, but the state said they didn't do it for a punishment reason, so we got to leave it up to the discretion of the state. So all they had to do was come up with an alternative reason why they changed the law, and then it stuck. You said that's why I have an issue with ex-cons not being able to vote, even though they've done their time. Yes, that's my thing. If you've done your time, like I am really an advocate of redemption and grace and mercy, because but for the grace of God, there go I. And if you think somebody has not changed, or if you think that you don't want this you don't like their background, don't vote for them. That's it. But I don't think the government should be able to tell me who I should be able to vote for because you changed the law so that they don't even have an opportunity. Because no matter what people said about our former mayor, okay, he had his indiscretions, but did he do a lot for the city? Absolutely. I think he did a whole lot for the city of Detroit. Most of the people that got caught up in the gang, I think they did do a lot. Some people just are young. Like I think people forget how young Kwame Kilpatrick. He was like 30 or 32, and he did a lot of immature things during that time. But we all knew he had potential. Like individuals believed that he would be the first Black president. And I went to his trial, and they watched him. His first political gig was he was a state senator, and then he became mayor. The feds watched him all the way up to the state senate and watched every move he made that was jacked up, and they threw all that at him when he went to trial. And he got like 26 years, 23 years, something I was like unheard of, just to make a point. I come to tell you. Florida is a state that doesn't want ex-cons to be allowed to vote. I have read. That's terrible. Yeah, that trial was crazy. Thank you so much for the super chat. But yeah, it's so that's why this case, I know I usually stay away from these types of cases on here because I think differently, and I don't ever want to make it seem like I don't empathize with victims, or that I don't empathize with, those that have been, again, the victim of a crime or the situation. But I am trained to look evenly and to make sure that I'm fair, as my approach is. And I feel like if you go to jail for something and you pled, especially, I don't feel like the government should be able to just tack thousands of more like criterias on you. Like, give it to them all at one time. If you don't give it to them, because most people plead because it's better than what the outcome can be. That's what they plead for. So what's the point of pleading if you guys can just go back and go get some type of, come up with some regulation, and then I'm jacked up either way it go. Black folks always have to be above board. Meanwhile, the Trumps are yep. That case, one of the cases I did, it was a public person. I'm not gonna say their name because they still kind of in hiding. But it was the craziest case. Like, she didn't really, in my mind, she didn't really do anything. That's another thing with politicians. You guys have to know the rules, especially if you're black. If somebody takes you out to dinner, pay your own bill. Because anything over $25, they're going to say it was a bribe. If somebody has contracts with the city you work in and you're friends with them, I don't care if you went to high school with them, don't vote on that contract. If somebody has a contract with the city and you short $20 for your rent, do not get that $20 from them, because that's considered a bribery. It's a statute. It's I just remember 666. I was like, this mug is of the devil when I saw the statute. And they get you under it. They get all these, and they watch you. They watch you. That's why people can't tell me that things are equal, that we're all on equal footing, because it's not. It's not true. So every chance I get, I kick up dust. Sometimes I go into situations where I raise eyebrows for judges, where now they like, oh, okay, I gotta really think. I've made a lot of judges think of some things. And sometimes it's the principle of it all, you know? So thank you so much. I like all of my what is all of this? You guys delete this. Is it any mods in here? Delete this person that's doing all of these letters. I don't know what this is. Hey, Raymel. This top G. Delete this. He's trying to spell. Really? You blocked. Take this top G person. Take them off of the block them. Is it any mods on here? Thank you. Yeah, they on here trying to spell. Don't let me let you know who I really am, calling me a NI whatever. That wasn't cool. It's okay. I'm gonna have to add more mods on here when I get off. I'm gonna have to, Jeff. I'm gonna have to make you a mod. Our legal system is always finding new ways to keep people of color under control. Absolutely. All right, I'm gonna add some more mods. Chat, ain't nobody saying nothing bad about Nicki Minaj. So I don't, if anything, I'm saying that her husband should be suing. So I ain't understanding why you all upset. But anyways, all right, y'all. I'm about to get off. I hope you guys enjoyed the commentary. To all those that watched the replay, tried to break it down on the lawsuit. Thank you guys for hanging out with me as always. Thank you guys for handling the chat. These people out here tripping today. Goodness. Yep, I have to. What you have to do, guys, I can't make you mods on my StreamYard. So if you go back like in my chat, I can do it while you're in the chat, like when I'm off. Thank you. Thank you. But yeah, I'm gonna add more mods on here. Thank you so much, Ken. Guys, I hope you guys have a good night. All right. Y'all DM me if you wanna be a mod. DM me because I'm not gonna remember. And I'll try to do it for the next time I come on. I love each and every one of you guys. I hope you guys enjoyed the show. And I am going to talk to you guys hopefully soon.